Welcome. Good morning, good afternoon, good evening, depending on where you're joining us from. Thanks very much for attending this SCMA webinar, Recent Developments in Maritime Law and Arbitration, Views from England and Singapore. I'm Puneet Oza, Executive Director of Singapore Chamber of Maritime Arbitration, SCMA. SCMA is a part of a global ecosystem of maritime arbitration centers and offers an effective and flexible framework for resolution of maritime and trade disputes, for those of you who don't know more about SCMA. Situated in the world-leading dispute resolution center of Singapore in the heart of Asia, we sit with distinct advantages of proximity to Asia and the rich and diverse panel of arbitrators who understand Asia. While we sit with these advantages, the industries we serve are global, and therefore constant knowledge upgrades covering aspects from all over the world are one of the key offerings of SCMA. With COVID-19 challenges, webinars have been the way to reach out to the maritime, trade, and legal communities. The benefit, of course, is that we can reach out to a global audience instantly, while the downside is the missing feel of a face-to-face interaction and networking. Let us hope that we can all get back to meeting face-to-face as soon as possible, though I feel the hybrid model will stay with us even after that happens. I would like to thank my entire team at SCMA Secretariat for their amazing efforts. We've hosted 6 webinars last year, and this year we've already been part of 8 webinars, and this being the 9th one. I've often said that knowledge alone is not power. Actionable knowledge is. We are constantly trying to host events that disseminate actionable knowledge so that practitioners and professionals can directly benefit from such knowledge and make better decisions. Today's event is no different. We have a wealth of experience on the panel today and topics as diverse as conflict of interest, to disclosure, to e-bills of lading, to digitalization's impact on maritime arbitration. Let me introduce Dr. Colin Ong QC, who has graciously agreed to moderate the discussion today. Dr. Ong has sat as arbitrator or acted as counsel in over 380 arbitrations worldwide. He's ranked as a thought leader by Who's Who Legal in Arbitration Construction and Litigation 2019-2021. He's also ranked as top 30 global arbitration practitioner by Expert Legal Guide's Best of the Best 2017 to 2021. He's also a panel arbitrator of SCMA and sits on the SCMA's promotion committee. Thank you so much, Dr. Ong, for all the support and the efforts. It's also heartening to see that 4 of the 5 panelists are also SCMA panel arbitrators, and I do hope Mr. Weinl will also consider coming on board SCMA's panel in the future. I would like to end my remarks by also thanking the rest of the eminent panelists for their support and efforts. Over to you, Dr. Ong, to introduce the panelists and take the event forwards. Thank you very, very much.
Thank you for the introduction, Puneet. Good morning, good afternoon, and good evening to all of you, wherever you may be situated. And thank you very much for joining us. It is indeed a privilege for me to be able to share the cream of the crop of the English and Singapore bars. Let me first explain how this webinar will be run. Each speaker will deliver his or her respective main topic, and then a speaker from the other jurisdiction shall then step in to provide short comments on the subject matter from his or her jurisdiction. And this interchange of speakers shall be repeated until all 4 topics have been covered. We shall then open up the platform and deal with any questions that you may have. Please do type in your questions into the Q&A box on the Zoom platform. So Q&A box, please, not the chat box. And at the end of the webinar, we shall flash a post-webinar survey QR code to allow attendees to provide feedback. We shall now hear from our illustrious speakers. The first topic that will be covered in today's webinar will be an analysis of the English Court of Appeal's decision in Secretariat versus a company. The decision came out earlier this year. The English Court of Appeal upheld an injunction granted by the Technology and Construction Court, which prevented Secretariat, an international consulting firm, from providing expert witness services for opposing sides in two separate but closely related construction arbitrations. This is the first case where the English Court of Appeal has had to adjudicate on duties imposed on an expert concurrently engaged in two potential conflicting engagements and whether those duties tie up all relevant entities within the expert organization. We are fortunate to have Basanti Salvaratnam QC with us here today. Basanti will delve into the more important details of the Secretariat decision and will explain the important principles laid down by the English Court of Appeal. Following that, Kenny Yap shall give his comments on the same issues of apparent conflict of experts from a Singapore perspective. So please allow me to introduce our first two speakers. Basanti Salvaratnam QC is a senior silk at 36 Stone, practicing as both counsel and arbitrator across a wide range of industry sectors. She regularly handles multi-million-dollar commercial disputes in shipping, trade, and commodities. She also does banking and finance and insurance, and is a panel member of the SMA and SISC. Mr. Kenny Yap is a senior accredited specialist in maritime law. He is co-head partner of the Maritime and Aviation practice, as well as the head of the shipping contentious team at Allen and Gladhill LLP. He has been in practice in Singapore for more than 28 years, specializing in maritime and shipping dispute resolution. He acts regularly as counsel in shipping disputes. Without much further ado, I now invite Basanti to present her paper and then to Kenny for his comments. Basanti, the platform is yours.
Thank you very much, and greetings to everyone. The English Court of Appeal's recent judgment in Secretariat Consulting against a company considers conflict of interest arising when experts from the same international group are appointed on opposing sides in related arbitrations. And as Dr. Ong has just explained, the Court of Appeal dismissed an appeal from the Technology and Construction Court and upheld an injunction that prevented an international expert services firm, Secretariat International, from acting for two parties in a construction dispute. That was despite the parties instructing different legal entities within the Secretariat Group that were based in different regions in different, albeit connected, arbitrations. The case was the first time the English courts had faced a scenario where, to use the words of Lord Justice Coulson, there are two existing litigation support and expert retainers, which each client wished to maintain, relating to two live arbitrations, where what the respondent says is the same expert organisation will be supporting, advising, and giving evidence for and against the same client about the same project and the same or similar subject matter. The judgment is important because it provides guidance as to whether experts are fiduciaries and as to how far an expert's contractual duties to avoid conflicts of interest may extend. The TCC at first instance had caused some alarm when it granted the injunction on the basis that Secretariat owed fiduciary duties. However, the Court of Appeal rode back from that, limiting itself to finding that Secretariat and its subsidiaries were bound by and in breach of contractual duties to avoid conflicts of interest. So let me give you a little bit of factual background. Secretariat provides litigation support services and acts as delay and quantum experts in construction arbitrations. The defendant, who I shall refer to as A or Company A, was the developer of a large petrochemical plant and had engaged a third party as a project manager. Company A had also instructed a subcontractor to construct facilities for the development. Disputes concerning delays arose with the subcontractor, who then commenced an ICC arbitration against Company A, and that's in Arbitration 1. Company A then approached another entity in the Secretariat Group, SCL, for expert services in connection with Arbitration 1. SCL signed a confidentiality agreement subject to English law and also agreed a clause dealing with conflict of interests. And I'm now going to attempt to share my screen in order to show you that, that clause. In fact, it may just be easier if I do that now. So as we can see, the conflicts clause provides conflicts of interest. SCL has confirmed that it has no conflict of interest in acting for A in this engagement. SCL will maintain this position for the duration of SCL's engagement. SCL ran a conflict check across all entities in the Secretariat Group before it had signed up to that conflicts clause, and had concluded that there are no conflicts. Subsequently, the third party commenced an ICC arbitration against A. I will call this Arbitration 2. The issues in Arbitration 2 were directly connected to those in Arbitration 1. In Arbitration 1, the subcontractor claimed against Company A in respect of additional costs due to delay arising from the late release of certain designs. And those designs were to be prepared by the third party, who had commenced Arbitration 2 against Company A. And in Arbitration 2, that third party claimed for unpaid fees, and Company A counterclaimed in respect of delay and disruption to the project, including any liability which it was subject to in Arbitration 1. The third party asked another company in the Secretariat Group, SIUL, to provide quantum and delay expert services in connection with Arbitration 2. Now, upon discovering this, Company A informed SCL, its expert, that this engagement created a conflict of interest. A third Secretariat company, SAL, denied that there was any conflict of interest, and Secretariat sought to justify accepting both retainers as information barriers had been put in place and the experts were appointed in different disciplines based in different regions and engaged through different companies. Company A remained unhappy and successfully applied for an injunction from the TCC restraining Secretariat from providing services to the third party in connection with Arbitration 2. Now, in a first for English law, the TCC had held that Secretariat's appointment as an expert by Company A had given rise to a relationship of trust and confidence between them. And accordingly, Secretariat owed a fiduciary duty of loyalty to A. Acting against it in Arbitration 2 was therefore a plain conflict of interest. And it was further held at first instance that the duty was owed by Secretariat as a whole, because the companies in the group were marketed together as one firm, and there was a common approach to the identification and management of any conflicts. Now, when the matter reached the Court of Appeal, there were 4 issues that arose. And I'll share my screen again so that you can see what those 4 issues were. As you can see, the first was, did SCL owe a fiduciary duty of loyalty to Company A? Secondly, did SCL owe a contractual duty to A to avoid conflicts of interest? Thirdly, was that duty also owed by other Secretariat entities? And fourthly, was there a conflict of interest on the facts? So turning to that first issue, although there was no direct authority in point, the court considered a number of cases that were concerned with the duties of experts. And of particular note was a decision of the UK Supreme Court in Jones and Caney in 2011, in which the court had held that an expert's overriding duty to the court or tribunal does not preclude that expert from also owing fiduciary duties or duties of loyalty to the client. Going further, Lord Justice Coulson noted that complying with the duty to the court or tribunal was, quote, the best possible way in which an expert can satisfy his professional duty to his client, close quotes, because the client's interests are best served by experts who provide honest, independent, and objective pretrial services and evidence. Accordingly, and given that fiduciary relationships can be found in novel contexts, the court did not rule out the possibility of experts being fiduciaries. However, the court was conscious that there was a lot of legal baggage attached to the label of fiduciary, and there could be unseen ramifications from finding a fiduciary relationship, and that it was undesirable to conclude there was one unless it was necessary. Now, in this case, the conflicts clause meant that a fiduciary duty would not add to or enhance the obligations owed by SCL. So accordingly, there was no need to consider that issue further, beyond noting that a clause like the conflicts clause imposed a duty of loyalty similar to a fiduciary duty without all the legal baggage. So turning to issue 2, did SCL owe a contractual duty to avoid conflicts? As we've seen, the wording of the conflicts clause was pretty clear. And in the court's view, it meant that SCL not only confirmed that there was no conflict of interest at the time of the agreements, but it also undertook that it would not create any such conflict of interest in the future. Accordingly, SCL owed a clear contractual duty to Company A to avoid conflicts for the duration of their retainer. Issue 3 was the contractual duty owed by other Secretariat entities. On the facts, the court held that the duty extended to the whole Secretariat group. And that was because, in addition to there being a confidentiality agreement which was highly restrictive, the drafting of the conflicts clause had been based upon a conflicts check that had been carried out in respect of all Secretariat entities. The court gave short shrift to the argument that this amounted to piercing the corporate veil. Both SCL's communications with Company A and Secretariat's general marketing represented the group as a single global firm, and the individual entities within it as simply local offices. Clients, including Company A, were entitled to treat Secretariat as their expert, rather than the particular individual within SCL, SIUL, or another individual entity in that group. The fourth issue on the facts was there a conflict. The court had no difficulty in concluding that there was a clear conflict of interest between SCL acting for Company A on the one hand and SIUL acting for the third party on the other. And on the facts, the overlaps between arbitrations 1 and 2 were held to be all pervasive, covering both parties, role, project, and subject matter. So I'm now going to turn on to consider implications and make some observations about the decision. That the Court of Appeal shied away from establishing a novel category of fiduciary relationship doesn't put the issue to bed. However, at least in the field of commercial litigation and arbitration, the issue is likely to be largely academic, because the terms on which an expert is engaged will almost invariably contain a provision like the conflicts clause that we saw in this case. The scope of the expert's contractual duty of loyalty is unlikely to differ radically from any fiduciary duty that he or she might owe, and the former may well prescribe the latter if it exists in any event. Nevertheless, the decision does remain significant. Provisions like the conflicts clause are common, and of course, as with all contractual provisions, each must be interpreted in the usual way of looking at the words used in their context. And as the court emphasised, whether or not there is in fact a conflict is a matter of degree to be determined on a case-by-case basis. However, the judgment does provide useful guidance and serves as a good illustration of what can go wrong if you forget to check the small print. Although the case involved some distinctive construction industry elements, The problem of advising on overlapping disputes is very familiar to experts in a wide range of industries, including shipping, insurance, and commodities trading. And as we know, there are now many multinational companies that employ numerous experts in overlapping fields operating out of numerous jurisdictions. Now, in some industries, the consolidation of individual experts within a handful of major multinational outfits already causes legal advisors to race to engage their preferred outfit. In some fields, the potential for conflicts is made more acute due to the firms involved providing their services not just as experts, but also as consultants to industry clients in the day-to-day operation of their business. One can think of surveyors and marine engineers to take two examples. Indeed, that practice is usually welcome because it enables the expert witness to remain current on industry practice. An expert witness is an individual, and yet one generally expects that individual will discuss matters with his colleagues in a firm to test theories and draw on firm-wide experience. Nowadays, at least in the case of international industries, it's almost impossible to say in practice that one individual expert in a firm is a member of one office in one location or jurisdiction. The reality is often that they are a member of an international group of individuals who all work together to one degree or another. Now, the Court of Appeal did suggest a possible solution for those concerned. And I'm quoting now from Lord Justice Mayles at para 123 of the judgment. He said this: an expert witness group which operates on a global scale with separate subsidiaries in a variety of jurisdictions can, if it wishes, make clear that any conflict search it carries out and any undertaking which it gives is limited to the particular company being instructed and does not extend to other companies in the group, which remain free to act for parties opposed to the client in the same or related disputes. However, the court also went on to acknowledge that such a provision may be less attractive to potential clients than a more comprehensive one. And to a great degree, that may be so. One potential client may be less convinced, for example, about the reliability of the firm's inter-office information barriers than another. But the small print in the conflicts clause is not the end of the matter. In Secretariat itself, the degree to which the entity marketed itself as a single organisation was very significant to the outcome in the case. For instance, the individual experts all had Secretariat International in their email address, regardless of which company in the group they worked for. They were also listed together on the same website as key professionals within the Secretariat International team. And that was an important factor in the Court of Appeal's reasoning. It's easy to see how such matters would inform any court when seeking to interpret and apply conflict provisions. Of course, the reality is that multinational organizations have good reason to market themselves under a single reputable brand. And that's especially the case in international industries that demand high levels of expertise across various jurisdictions. The unfortunate saga of the Secretariat case does not necessarily mean that such multinational firms must accept a more disintegrated market presence if they wish to retain the ability for their subsidiaries to act in overlapping disputes. But the case does strongly suggest that those firms should take care to ensure that irrespective of their marketing, they clearly, openly and candidly establish the boundaries of their conflict provisions with their clients before they are engaged. And I'm now going to hand over for some Singapore perspectives. Thank you.
Thank you, Basanti, for that very clear and succinct analysis of the Secretariat case. I will now say something from the Singapore perspective. Let me start by saying that I've not been able to find any Singapore decision where the Secretariat case was cited or considered. Okay, this is perhaps not surprising since the decision only came out in January this year. Now, English decisions are not binding on the Singapore court, but it is likely that the Singapore courts would give English decisions considerable weight since Singapore also has a common law legal system. So if a case on the same facts as the Secretariat case were to occur in Singapore, I think it is likely that the Singapore court would follow the English court's decision in the Secretariat case. And like the English Court of Appeal, I doubt the Singapore court would readily impose a fiduciary relationship on an expert, particularly in a situation where the relationship between the parties is already defined by contract. Now, in other words, the court will probably undertake the usual contractual analysis of determining what were the terms of the contract, whether there was any breach of contract, and if so, what remedy would be granted by the Singapore court for such breach. Now, although there's been no reported Singapore decision on the Secretariat case, I understand that the Secretariat case was cited and considered in a recent Singapore-seated arbitration. Okay, it arose in a situation where one party to an arbitration applied to the tribunal for an injunction to prohibit the other party from continuing to engage its expert on the grounds of conflict. Now, the conflict allegedly arose as a result of the two parties' respective expert company merging midway through the arbitration. So let's say, for example, you have claimant appointing company A as his expert and respondent appointing company B as his expert. So what happened on the facts of this case was that midway through the arbitration, company A and company B decided to merge. And so the result of this is that the parties then belong to the same company. Okay, so although the case of Secretariat was cited and considered, ultimately I understand it was distinguished on the facts, and no injunction was in fact given by the tribunal in that case, simply because the factual scenario was different. Okay, so to summarize Singapore position, I would say that Singapore is likely to follow the UK. This would probably mean looking at the contractual situation rather than imposing a fiduciary duty. And whether the court or tribunal will grant an injunction or the appropriate remedy will therefore likely depend on the facts of each case. So with that, I hand it back to our moderator, Dr. Ong.
Yes, I'm just trying to, yes. Okay, thank you, Basanti and Kenny, for your respective presentations. We now turn to our second topic of the day, dispute resolution in the digital age. In the old days, business people would travel across borders and even oceans to meet each other and finalize the possibilities of concluding the deal. After reaching agreement, they would sign a written contract and have a handshake, which was also treated as a bond. And those days are long gone. With the new pandemic era that we live in, we no longer have that luxury of that handshake. We are unable to meet face to face, and we text, we Skype, we conduct Zoom calls, Teams, everything online. We rely a lot on emails. In short, we're almost completely, if not fully reliant on the internet in this digital age. But what happens when disputes arise? How do we deal with dispute resolution in the digital age? And what is the impact of artificial intelligence on the legal and maritime worlds? Today, we're fortunate to have Professor Leslie Chew, Senior Counsel, to discuss his views on those issues which impact on both the legal and maritime industries in Singapore. We shall then have the privilege of a short commentary from Mr. Nicholas Vinyl, QC, on his views on the same subject from an English law perspective.
Let me introduce our next two speakers. Professor Leslie Chew is the Dean of the School of Law at the Singapore University of Social Sciences. He's also Senior Consultant at RHD Law Asia LLP in Singapore. He's the founding and current Dean of the School of Law at the Singapore University of Social Sciences. Leslie has practiced law in one form or another for over 4 decades. He was appointed senior counsel in 2000 and currently is a senior consultant at RHD Law. And our next speaker, Mr. Nicholas Bynell, QC, is a leading silk specializing in international arbitration and commercial litigation, with particular focus on shipping and arbitration, and shipbuilding as well. Nick regularly appears in the UK courts and in a wide range of arbitral tribunals, both domestically and internationally. He has a particular reputation for his work in the Far East. Nick accepts appointments as arbitrator and has sat as sole and panel arbitrator under a number of rules. He also sits as a deputy high court judge in the commercial court in London. So I now invite Leslie to give his presentation, to then be followed by Nick's comments. Leslie, the platform is yours. You're on mute. You're on mute, Leslie.
I apologize, folks. That's one of the pitfalls of being online. Thank you, Dr. Ong. I merely wanted to say greetings to all of you, and what a privilege it is for me to be part of this group. And at this point, my topic is about dispute resolution in the digital age. I'm afraid we are now segueing from something very substantive in the Secretariat case to a little bit of crystal ball gazing, and also some observations on my part. Of my views are, of course, mine alone, and you're welcome to seek some clarification and debate with me at the appropriate time at the end of this seminar. But basically, I think we need to address the issue of dispute resolution in the digital age from the point of view that we know digitalization is disrupting our industry. By industry, I mean law industry, whether we sit as arbitrators or judges, or we practice as lawyers or counsel, or in whatever other related form. So the point that is important for us to bear in mind is that things will change. The way you and I have practiced, the way we view the law will certainly be different. Even now it is different, but it can be even much more different in perhaps a decade or so. There are 3 ideas that I would like to share in terms of dispute resolution in the digital age. First, online dispute resolution, as the literature will normally refer to, in short, ODR, is not new. Second, today, it has evolved into a much more sophisticated state than it first started. And I'll mention a little bit more about how it began. And now, in the midst of the current pandemic, we will notice that it's become even more critical, as well as really, really in the forefront. The third idea I'd like to share is that ODR is going to evolve to such a sophisticated state in the coming decade or so that we will have no choice but to confront the impact it will have on our legal industry. So let me begin with this, the first idea. The first idea, or the first point observation that I want to make is that ODR began maybe about 2-3 decades ago. In the 80s, 90s, it began to gain ground. And really, much of its was seen in the mediation sphere, simply because it was a matter of using the online platform to facilitate cross-border conversations, on-screen, off-screen, whatever form you want to take. So just to give you a concrete example, in the 90s, the judiciary in Singapore pioneered, in this region at least, online mediation for parties to actually simply log on and set up their own negotiation process one-on-one, and at some stage with the intervention of a mediator provided by the courts. In fact, it was so successful, the United Nations awarded the Singapore judiciary some award for that. But the ironic thing about Singapore is that we are so small that it really didn't make sense, and it was abandoned for better systems. But right up to the 21st century, the lower courts in Singapore does participate in quite a bit of online mediation together with their counterparts overseas. So while I was in the state courts, I was there till 2014. We frequently had online mediations with our Australian counterparts, for example. So it would be a mediation of a dispute, whether it's a Singapore dispute, an Australian dispute, but the mediators would be from two different jurisdictions and sitting far apart, but online, and with the parties on camera. So that's the background to what I think pretty traditional, pretty not so sophisticated online dispute resolution, because it doesn't require very much to do that. But today, ladies and gentlemen, if you look at what's happening today, legal technology has advanced to such an extent that you can see for yourself that there are so many of us today logged on to this webinar from very different parts of the world. This is the platform we're using. And during the pandemic, all judiciaries have conducted hearings based on one platform or another online. So it's gone further one stage. So it's no longer just doing mediation, but you actually have live hearings online. In Singapore during the pandemic, even serious criminal cases were heard over Zoom, and to some discomfort of some lawyers, but eventually people adapted. So that you can see it has moved on. Now, all these are simply supportive measures. In other words, we use a digital platform to conduct what is essentially still the same process, meaning you can have an arbitration online, but you still have talking heads, right? You still have an arbitrator talking, two counsel talking, witnesses being examined online. So what's happened in that kind of a situation is that it's not truly digital. It's just the platform is digital, but we move what we are doing onto the digital platform. But in the background today, ladies and gentlemen, there is a lot of research going on by scientists and technologists, as well as people trained in the law around the world, looking at really going through the next step, which is actually using technology to replace some of the functions that we traditionally do. So as I'm speaking to you, and if you're interested, you can hereafter, after this session, go into the internet and check it for yourself. In England, very recently, they introduced what's called money claims online, MCOL. So for small claims, you can actually log on into this platform in England and have it adjudicated in a process where two parties are involved. Granted, it is still small, limited to small claims. But what I'm trying to suggest here is that this is the beginning, right? And technology is going to develop further to make it even better. The real challenge for us in the industry is when digitalization allows parties to actually resolve disputes, not just by using the platform, but actually using the machinery itself. In other words, you don't even have to appear on camera. You go online, you key in your parameters, and the process will take over the whole entire dynamic of that dispute resolution. Now, you can see that if you look at the MCOL example, you can deal with small claims by filling in forms online. Now, this is still very nascent. Again, currently, as I speak to you, earlier this year, the Singapore judiciary, through its arm, Singapore Academy of Law, its academic arm, launched what's called the outcome simulator for motor accidents. Again, you can go online and check it out for yourself. If you have a motor car accident and you have a claim against a party that has wronged you, basically a tortious claim, you can input the parameters of that accident and the injuries that you have suffered and so forth. And the outcome simulator will be able to calculate approximately to what extent each party is liable. So it could apportion liability between the claimant and the tortfeasor. So for example, it could be 40%, 60%. Now that's being done all over the world manually. But now in Singapore, we've launched that outcome simulator. Now it serves only as a guide at the moment for the judiciary. But you can see that when you have input into it, artificial intelligence or more advanced algorithm systems, you can see how it can progress. Now, my third point, therefore, my third observation is about artificial intelligence. Currently, there's a lot of scientific research going into deep learning and neural networks, which will actually allow the algorithms that can be designed to mimic the mental processes of a human being. So if you think it's science fiction, it is not. For too long, a lot of us in the law think that we have a monopoly on analytical skills. But let's examine very quickly what we do as people in the legal industry, right? Particularly lawyers and judges. What we're doing is we get information from our clients or from the parties. We then collate that information and analyze it on the basis of logic. And then we produce an outcome, essentially based on logic and hopefully with a pretty rational outcome. And that's the experience for most of us. By and large, we will get reasonably logical outcomes. That sort of dynamic is perfect for computers and computer language. Algorithms can be designed, especially if you input the advances in artificial intelligence, to not only assist the process to some extent, actually replace it, at least in some portion. True, many things currently are designed for small claims, but I'm saying that we cannot assume that it will remain so. Let me just give you an example. For those of you who are interested in technology, you should go and check out the famous experiment where a computer program was designed to pit itself against a grandmaster in the game of Go, or in Chinese is Weiti. This is a strategy game, right? So AlphaGo, the program, was designed and it played against a grandmaster from Korea. He's ranked like number 4 in the world or something like that, and actually beat him 4 out of 5 games. You may think that, well, that kind of algorithm designed is purely for playing a game. But what stunned even the programmers themselves in that experiment was the fact that when AlphaGo beat the grandmaster, there were several moves and strategies that AlphaGo, the program, actually learned itself. It was never taught. In other words, it was not programmed to make those moves. But by playing a number of games with the grandmaster, the computer program decided that it could adapt and find a strategy that could overcome the grandmaster's strategy. That even blew the minds of the programmers themselves, because in other words, the programmers did not program that move, but the computer learned itself. So you can see where this can go in the future. Let me then end off by saying, what's the relevance to dispute resolution as a whole, and in particular to maritime arbitration? Now, maritime disputes, rather, more generally, the maritime world, the shipping industry is very much document-based. Now, when it is document-based, it is much easier to pattern it into something that a computer can understand and can deal with. In any event, all our disputes, as I earlier mentioned, are premised on the idea that we should be able to make sensible analysis of the dispute and come up with logical outcomes. And that, ladies and gentlemen, is the best way of dealing with logical analysis is in mathematics. The highest form of logic is mathematics. And that's what drives the computer world. So it is not far-fetched that at some point, the marriage of artificial